in some jurisdictions. We are therefore reviewing whether or not we should maintain this requirement or modify it.
People who test positive for COVID-19 will still be required to quarantine and
from the Ministry of Education. Welcome to Ms. Chambers. And what I would ask is, before we go into the confirmation of the minutes, both for July 14th last year and February 3rd, is to ask whether or not they would like to defer this until the end of the meeting so people can get another chance to go through. And of course, we can raise any matters arising. I'm not sure if everybody got a chance to go through both sets of minutes. So, Member Gale, what is your suggestion, sir? You like to defer to the end of the meeting, or you want us to take it now?
We can defer to the end of the meeting here and just get to the meat of the matters.
All right, okay. So we are anxious to continue the matrix. This matter in relation to the harsher penalties was the advice given by the AG department was that the right place for it to come from would be the Ministry of Education. So what we can do is just have the Ministry of Education speak to that and any questions or clarifications, and then we can get right back to the matrix. So let me invite Ms. Chambers from the Ministry of Education and Youth. I'm not sure. Ms. Chambers, are you fully briefed on exactly what the committee is asking for? Not hearing. Is Ms. Chambers on from the Ministry of Education or any other rep from the Ministry of Education?
Mrs. Anastasia Gordon-Jones is also here from the Ministry of Education. Ms. Chambers should be here. She's legal officer from the Child Protection and Family Services Agency, but she may be having problems in terms of connection. So if she's not on, Mrs. Gordon-Jones will leave.
All right, is Ms. Gordon-Jones on from Education?
Good afternoon, Chair. Good afternoon, members of the committee and other persons on the platform. My name is Anastasia Gordon-Jones, legal officer in the Ministry of Education and Youth. Chairman, yes, we are in receipt of a letter dated February 18, 2022 from the House of Parliament, in which the Joint Select Committee has requested that the ministry provide clarity on the types of offenses considered in its proposal for harsher penalties based on the existing penalties and what the ministry was seeking to achieve with harsher penalties in keeping with the need to ensure there were no inconsistencies with other types of offenses in other acts. So this is what we have noted from the letter that was sent from the House of Parliament. So recall we made our submission last year, it was mid last year, in relation to the Cybercrimes Act. A proposal was made for harsher penalties in relation to children. We also made a recommendation to have the Child Pornography Prevention Act be merged in this legislation based on the fact that the current legislation as it is does not refer to child. And we were contemplating the use of the penalties under sections 4 and 5 of the Child Pornographic Act, which provides for sentencing of up to 20 years. So that was the premise on which we indicate the need for harsher penalties under the regulation, under legislation. I am not sure if the committee has in its possession the Child Pornographic Prevention Act, specifically the provisions under sections 4 and 5, which speaks to 4 speaks to producing, distributing, etc. child pornography, and under subsection 343 of that act, it speaks to a fine of up to imprisonment, of up to 20 years, and under subsection 3B, it speaks to a fine of up to 15 years. We note the Cybercrime Act speaks to under section 4 or clause 4, as it is now, a term that exceeds 1 year for, and I will just give me a second, let me get the act. Section 4 speaks to a person commits an offense if that person accesses any program or data held in a computer with the intent to A, commit any offense punishable by imprisonment for a term that exceeds 1 year. So what the ministry is saying in its submission, that it indicates a penalty that is up to 20 years if an offense is committed under section 4 that relates to a child, based on the provisions of section 4 and 5 of the Child Pornographic Prevention Act.
Member Campbell, would you want to make any comments, since you were the one that raised this issue in relation to, along with other members?
Right. Thank you, Mr. Chairman. I am hearing this, and I think it is really up to the representatives from the ministry to see if they're satisfied with what the ministry is saying, because at the time they said that they could not make a recommendation as to what offenses could be created. So I leave it in the hands now of the Ministry of Education, because they've got the opportunity today to make their case as to why their suggestion needs to be accepted or not accepted. So I leave it now to the two ministries. But I still support the idea that we must have harsher penalties for children who are in any way offended under the Cybercrimes Act. I do still support that idea 100%.
Chairman, could I ask a question? And I wasn't at the last meeting, so I'm not privy to all the deliberations, but is there a distinction made between an adult who commits an offense and someone who is considered under 18, or a child who commits an offense, in terms of the types of penalties that we're asking to be made harsher? I ask because under the Cybercrimes Act, there are certain offenses that certainly children or students could commit, and they do so in some cases out of immaturity and pranks and just plain stupidity. And I wouldn't want the same level of penalty to be imposed on someone who is under 18, or whatever the legal age is to be considered a child, versus an adult who is obviously engaging in something which is more exploitative. So I wasn't privy to last week, but I'm just asking if that was a distinction made when the discussion took place.
Member Robinson, this was children as victims. We weren't discussing them as perpetrators in any way. We were discussing if they were victimized using a computer, for example. Should the person who victimized the child be given a harsher penalty than if they did it with an adult? That was a discussion.
And I understand, Natalie, but I'm also saying children victimize children under the Cybercrimes Act. And there, it could be Section 9 around malicious communication. There are other things around cyberbullying. I'm just saying, in looking at making the penalties harsher, I just want some consideration to be given there where it may be peers who are doing it versus an adult who is doing it to a child. That's all I'm saying.
Got you.
All right, CTD Murray, you have any input on this in based on what Minister of Education has said? Is there anything further for Minister of Education?
Good afternoon, Chairman, members of the committee, colleagues. Our understanding based on the presentation just made from Ministry of Education is that their recommendation was premised on the basis that the provisions of the Child Pornography Act would be brought into the Child Pornography Prevention Act would be brought into the Cybercrimes Act. And then if that adjustment was made, then of course the penalties would have to be higher or harsher. That was what I took away from the presentation just now. And if my interpretation of what has been said is correct, I know that we had consulted with the Office of the Parliamentary Counsel on this specific recommendation from the Ministry of Education and Youth regarding incorporating the provisions of the Child Pornography Prevention Act into the Cybercrimes Act, and the CPC had a view, which I believe she can share, but, and I will stop there, Chairman, to allow the CPC to share her views on the incorporation as proposed, because if the committee, depending on what the committee decides with respect to that, it might very well be that we are going to have two substantively different legislation, and the matters as to the penalties would be treated within the more substantive one. But I will yield, Chairman, to the CPC so that she can treat with that specific recommendation from the Ministry of Education, Youth and Information in respect of incorporating the provisions of the Child Pornography Prevention Act into the Cybercrimes Act.
Good afternoon, Chair members. Thank you, CTD. Colleagues, well, we have covered this ground already when we have discussed the substantive proposal. Our view, of course, is that the Child Pornography Prevention Act doesn't only treat with child pornography when it is committed as a cybercrime. It covers child pornography where whatever the medium. So it would not be appropriate to incorporate the Child Pornography Prevention Act into the Cybercrimes Act. And further, as had been previously expressed, the commission of child pornography as a cybercrime would already have been covered by virtue of the provisions of Section 4 of the Act. Regard to the punishments that currently exist in the Child Pornography Prevention Act, that would have been captured here already under Section 4 of the Cybercrimes Act. So there's no need for any further provision to incorporate the Child Pornography Prevention Act.
Members, is that satisfactory?
Good afternoon, Mr. Chairman.
Afternoon, who is that, Ms. Chambers?
Yes, it is, Mr. Chairman. I do apologize. Have a bit of connection issue because I'm in court in St. Mary.
No problem.
Mr.
That's
Chairman.
good to know you're still coming through from St. Mary. That's fine. Go right ahead.
Mr. Chairman, And just a quick commentary based on what Ms. Grant from CPC had indicated. One of the presentation that we did last year was to ask a possibility of merging the two pieces of legislation. And the reason being, from our research, we saw that other jurisdictions have cybercrime and child pornography incorporated in the same legislation, but separated. Reason being because there are similarities between the two provisions. The Child Pornography Act is only 10 pages, and some of the information seems to, and it's my opinion, overlap within the Cybercrimes. Cybercrimes Act also don't make any reference to children, but yet some of the actions, as a previous member had indicated, that children do cybercrimes, they do cyberbullying, and they do similar activities based on computer picture. And so that's one of the reasons why we had asked for it to have, if not merge, have a reference to the Child Pornography Act within the Cybercrimes Act, because there's no reference to children under that legislation. So that's my 2 cents worth, Mr. Chairman.
Thanks for that. Thanks for that clarification, Ms. Chambers. Member Rodriguez, Member Gale especially, were very strident last week in relation to the clarifications. So other members, are we satisfied now to leave it with the Ministry of Education and MSET to fine-tune this aspect of the penalties?
So, Chairman, what I'm seeing is a situation where there's a recommendation to import aspects of the child pornography legislation that would have been relevant in treating with the Cybercrimes Act into the Cybercrimes Act legislation. That's what I'm getting. I would leave it for the Ministry of Education and MSET to carve out the most relevant approach, but I also accept and understand the recommendation made by Member Robinson in terms of making a distinction in terms of the penalties as it relates to a child perpetuating the act as opposed to an adult, and have a different scope of penalty. The proposal by us is to really create some sort of a deterrent in this situation, and that such deterrent must be flagged in the legislation, especially right now where there is no mention of it. So I believe those who would have proposed the change, including the Ministry of Education, is against the background that there's an absence of treating with it now, and there ought to be a suggestion that this particular legislation that is being proposed for changes is to incorporate such deterrent. That's my understanding. And I support that type of approach and ask for some, collaboration between the two ministries to infuse some sort of a provision.
Point well taken, member. Supported. Any other members would like to raise any issue before we close this and allow the Minister of Education to complete and move on to MSET with the matrix?
Chair, may I? Not a member, Marlene Aldred.
Oh, sorry, I didn't even realize. Of course, SG, any time of the day or night you can contribute.
Thanks, Minister. Good afternoon, Minister, members of the committee, colleagues. I actually support what the CPC has said. I actually do not agree that we should be moving or trying to collapse the Child Pornography Act into the Cybercrimes Act. The first thing is, child pornography does not fall within the portfolio remit of MSET. It falls under another ministry. That act was implemented to give effect to international obligations. And it's a discrete piece of legislation that goes beyond cybercrimes. The intention at that time, and I don't know that the policy has changed because I've not been advised of any policy change. The intention of the policy at that time in implementing that act in the manner in which it was done was to ensure that we fully comply with our international obligations. And so for MSET to take this on when it doesn't fall within the portfolio remit of MSET is not something I can support. And again, to emphasize, it's wider than cybercrimes. So if there is an issue, and I also don't see a loophole or a gap, because based on Section 4 of the Cybercrimes Act, you can then prosecute matters relating to child pornography that have a cybercrime element. So I don't support the approach being proposed. I also just wanted to make another comment, and that was in relation to, because I thought something else was being said, which was that the penalties now in the Cybercrimes Act should be, there should be like an additional sanction then, so to speak. So right now, if you have a penalty of 15 years, there should be an additional penalty if the victim is a child. I think that is what I was understanding a part of the proposal from Ministry of Education. And if that is so, they really would need to now explain what is this additional penalty that would apply, especially since reference is made to penalties of 15 and 20 years in the Child Pornography Act. And when you look at the Cybercrimes Act, you already have those types of penalties already present. So I'm not sure how much harsher they would want the penalty to be if the victim is a child. So I just wanted to throw my 2 cents in. Thank you very much, Chair.
So SJ, with that said, what would your recommendation be in relation to how we move forward in terms of the MOE presentation, and how that would fit the MSET's?
Well, as it relates to merging, this is a bigger issue because it involves another ministry and it involves a major policy shift of the government. I'm not sure that that can be handled in this forum in this manner. It would have to also involve cabinet. And again, remember, we were implementing international agreements, obligations when we did the Child Pornography Act. So there is that. As it relates to additional penalties, Ministry of Education would need to be a lot more precise and specific in identifying the actual provisions in the Cybercrimes Act that they would want amended and how they would want, and the actual penalty that they would want to impose. We'd need more detail on that. They would need to explain a little bit more. So I know that Mrs. Gordon-Jones referred to Section 4.1 and a penalty of 1 year. It's not a penalty of 1 year. That's just a provision that allows for jurisdiction to be, for you to have jurisdiction under the Act. It's not a penalty. So the penalties already in cybercrimes, from my perspective, do seem to, they are consistent for the most part with the Child Pornography Act. So I think if Ministry of Education and Youth has a difficulty then and thinks that they need to be, for want of a better word, beefed up, then they would need to now tell the committee which penalties need to be increased and by what amount.
Member Longmore, your hand is up.
Yes, Chair, thank you. I'm a bit indisposed, kind of multitasking, so I'm not able to open my camera. I just want to chime in here. I have listened to the discussion from last week. I was also a member of the Joint Select Committee on the Child Care and Protection Acts, and I remember us going into grave details around this matter. So I don't know if Ms. Aldred could also relate to that, or going forward, that we could consider that. But the the allegations are so being made if in the case of against a child, one of the main things that we considered was that it would be escalated automatically to being a criminal act and the penalties subsequently following suit. So I know that Senator Campbell Rodriguez is concerned that I very much am aligned with in terms of the protection of our children. I just would like to reassure that we considered this under the Child Care and Protection Act. And personally, at this point, I think that with the expedience of the Cybercrimes Act that is needed, I think that we need to bear that in mind going forward in making sure that this act gets to where it needs to get to for us to basically be able to actually prosecute, because these crimes are actually happening now. And the longer we delay is the more of such perpetuation that would be happening. Thank you, Chair.
Thank you, member. Is there any other member that wants to contribute? All right, so we'll be guided by this and have further discussions, MSET team, in relation to how we are guided based on the SU's advice. Thank you very much to personnel from Ministry of Education for giving us your input. And of course, the discussions will continue off of the platform. CTD Murray.
Thank you, sir.
Over to you.
Thank you, Chair. One moment, please. Can the members confirm that they are seeing my screen?
Yes, ma'am.
Okay. So
yes, I can see that.
Thank you. Chairman, members, we concluded at the last sitting at section 8, and we are now at section 9. Members would have received the full matrix in respect of the comments on the various sections of the legislation. I propose, Chairman and members, to and you would have noted, and I believe I would have said this already, that the advice of both the Attorney General's Chambers, the Legal Reform Department, and the Office of the Parliamentary Counsel would have been sought on some comments from the stakeholders. And of course, while I will treat with those matters that the MSET deliberated on, I will defer to the Legal Reform Department, AGC, and the AGC to treat with those matters that they would have opined on. With respect to section 9.1, there were several comments, Chairman, members, and I am proposing to take us through the comments or remind the committee of the various comments with respect to that section. And then I will treat with some technical questions that were raised around the section. And then I will hand over to LRD to take the committee through their own research finding and recommendations that they're making in respect of section 9. Members are reminded that section 9 treats with the use of the computer for malicious prosecution. So with respect to the Ministry of National Security, their concern was that the section needed to be amended to include data that is of a particularly graphic nature, such as violent events resulting in death or serious injury or maiming of a person. Their concern was based on the fact that there seems to be, in recent times, the sharing of these information the sharing of data of this nature within the public sphere, and there was almost a level of insensitivity to the victim and or the victim's family. So the recommendation was made for the inclusion of amending the Section 9 to include a reference to the sharing of data of a graphic nature. UE suggested that, from their reading of the section, that an angry, threatening electronic message could be construed as a cyber crime. And it was their view that a message such as that, angry, threatening, should not be considered criminal. And they would have gone into an example of what they were talking about, and then therefore claiming, suggesting that based on the current wording, it appears that such an exchange within the public sphere could be deemed criminal. With respect to the FSC, they noted that email spoofing involves a person forging the email address of someone else. And with that in mind, they recommended that there be a mechanism to verify the true identity of an email sender. The FSC thought that the act should then therefore be amended. Well, queried rather, my apologies. They queried whether the act, the provisions of the act as now worded, would capture messages matching the categorization that are broadcast to multiple persons via a social media platform. With respect to MoCA had at least 4 recommendations for amendment to the legislation. Their first concern, and I'm scrolling to that at the top here, they recommended that the criterion within Section 9 be made disjunctive, which would allow for a wider category of malicious communications to be criminalized, while simultaneously lowering the standard of proof required thereby. So that was one recommendation. Their second recommendation related to the need to include the subject of the communication as an aggrieved party. And the third recommendation they had was that consideration be given to including hate speech as a type of communication deserving of punitive treatment. And then finally, they also recommended whether the identification of malware, or rather whether malware should be identified as a malicious communication, and therefore should be stated explicitly in the legislation, or for neatness and convenience. The private sector organization of Jamaica.
Sorry, could I just ask a clarifying question, Joaquin? By hate speech, what could you give me probably an example? What are they referring to as hate speech? I think there's a definition which I can't recall, but I just wonder, we have defamation laws, etc. What would they consider to be hate speech to be included in as malicious communication?
Remember, I would have to look back at the more detailed submission to see if that was articulated. As it is now, I'm not sure if they had made a reference to what or how they would define hate speech, but that is certainly a matter that the LRD would have considered and would have some views to share with the committee on it. With respect to, so remember, I think the issues around that will be addressed in a little while. With respect to the PSOJ, they recommended that a schedule be established to identify what is considered to be obscene. And in the absence of a schedule, there ought to be trial by jury. Essentially, their contention is that the persons ought to know what the criminal action is that they are likely to be sanctioned for, or could possibly be sanctioned for. With respect to the JBA, as the Jamaica Bankers Association, their recommendation was for an inclusion of the mental element of recklessness. And then we have the Office of the the Office of the Director of Public Prosecution, ODPP, that basically suggested that Section 9 needed to be refined. They certainly identified gaps within the section that needed to be treated with, and their recommendations are outlined. Their first recommendation was that a definition of the term send be included, or send to another person rather, be included in the legislation. They also recommended that the actus reus regarding sending to another person should not be restricted to just mere sending, but should be widened to include distribution, publication, or making the material available electronically. They suggested that the term obscene should be deleted from this section, and that a separate offense treating with non-consensual distribution of private images be implemented, and that would essentially treat with revenge pornography scenarios. So that was a recommendation from them. And then finally, with respect to the term menacing, they recommended that if this is to remain a feature of the section, then a definition would be in order. So members, I will treat with the comments before I hand over to the LRD, the comments from Yui. So let's go back up, sorry. So Yui's observation that the act appears to criminalize the sending of angry and threatening electronic messages. We want to draw the committee's attention to the fact that the wording of Section 9, based on the wording of Section 9, a mere sending of an angry or threatening electronic message is not in and of itself a criminal offense. In addition to the act of sending such a message, the mental element of intention to harass the person or cause harm or the apprehension of harm would also be required. So the point here, members, is that the concern that just sending a message is sufficient is not in fact so. The actus reus and the mens rea are required, and so therefore, while the act might be done, the prosecution would also have to look at whether or not the mental element of intention to harass the person or cause harm was also present.
Are you saying, therefore, that the recipient of the message would have to demonstrate that they felt harm in the process and there ought to be evidence of such?
I am saying, Member Gale, that I believe that the prosecution would be under an obligation to prove intent.
To prove.
That the intention of the person in sending the message was to cause harm.
No, but work with me now. So John Brown sends me a message. And because when I received the message, it would have created great stress on my part. Is it for the prosecution to prove that the sender of the message was intended or not intended to do so? Or is it a situation where me being the recipient of the message, I would have gone through great psychological trauma Remember, in this case, we're trying to protect the victim as well as to instruct cause based on the intent of the perpetrator.
I hear you, member, and I'm not a criminal attorney or a prosecutor, but my understanding of how this would work is that there would be the victim would, of course, to whom you refer, would then complain to law enforcement, and then the law enforcement officers would have to do their own investigation into the matter to determine whether or not a charge should be laid. And so I would say that all of this would then become a matter of evidence, and the ability of the Director of Public Prosecution to determine that there is sufficient evidence to demonstrate, one, not just the actus reus itself, but also that there was an intention on the part. So I would suggest, Member Gill, that the evidence would have to demonstrate that would have to be sufficient evidence for an argument to be made that there was an intention for the perpetrator to cause harm.
Sorry, Ms. Murray, I'm just going to interject quickly. Mr. Chairman, through you. Ms. Murray, your position is correct. With all crimes, the actus reus and the mens rea must be demonstrated. So there is, I don't know, I suppose we could say there's method to the madness, but there is a reason for that. And in any event, it couldn't just be left up to the subjectivity of every single person to say, okay, somebody sent me a picture with a cake and there was somebody's face on the cake or something like that. I mean, it's not as base as that, but as with all things, we must always remember that one person might react a particular way to a particular image or the content of something, and we see that every single day, even with the COVID measures. You know, but at the end of the day, what was the intent of the person who sent the image or sent the note or sent whatever the situation is? That must be considered. It is very different, however, where someone, Ms. Murray, I'm not sure if you mentioned about that. I didn't hear you mention that, but if someone broke into someone's computer, took their nude pictures and sent it all over the place, or if someone took or in the case where they a man and woman, they had a particular relationship, they have nude pictures, and then send the nude pictures across the internet. That is clear what the intent is. But outside of that, in another context where a particular image is sent to, I don't know, just a random person or something to that effect, then the intent would have to be proven as well. And even in the case of a man and woman where nudes are exposed or explicit content exposed, that in and of itself would speak to the intent, because the intent in that case would only be to embarrass or cause harm or otherwise. So as with all other crimes, the mens rea and the actus rea, they must be shown to give that reasonable doubt, or to pass that reasonable doubt threshold.
Chairman, members, I'll proceed if there are no other comments on that one. With respect to the Financial Services Commission's comment, the concern raised by the FSC in our reading of their comments does not seek to criminalize the act of spoofing, but rather to legislate a mechanism to verify the identity of the sender of an email. For us, the recommendation to create a mechanism in law to facilitate the identification of, or the verification rather, of an identity is not supported. We don't see how this particular piece of legislation could have a provision that outlines a mechanism to verify the sender of an email. We do note that in cybersecurity generally, the act of verifying the sender of an email of email messages are skills that are reposed in this MIS officers, system administrators within the organizations, and settings that are made at the server level. So this is something administrative and would have to be set up in a way to ensure that the infrastructure, there is an ability to determine who the sender of an email is. So the imposition of a legal obligation on the recipient to confirm the point of origin within the context of the cybercrimes legislation is not something that we would recommend. With respect to MOCA and the aspect of MOCA's comments, members will recall MOCA had at least 4 recommendations, but the one that I'm going to be speaking to is the recommendation that consideration be given to whether malware should be identified as a type of malicious communication. The committee is asked to know that the use of all forms of malware to access, modify, impair, or intercept the contents of a computer or obstruct a computer is already covered within the sections of the legislation, and those sections being section 3, 5, 6, 7, and 7. Additionally, we note that based on section 10, the making or writing and otherwise making malware available with the intention to commit an offense under the legislation is treated within section 10. We also caution about, and this is something that we would have been doing before, caution the committee about avoiding the very prescriptive use of certain terminologies in the legislation, and so we don't recommend that that the reference to malware be included in the section 9 or anywhere in the act for that matter, for either neatness or convenience. We feel that the malware is a software that is used. We know what it is used for. It's usually disruptive in nature and would easily fall within, if used, would easily fall within either sections 3, 5, 6, and 7. And the making of the malware itself would be caught under section 10. We did, however, notwithstanding our own views on that, the recommendation, we did reach out to,
Sorry, can you help me back with 10? I'm sorry, Ms. Murray. You said section 10 would help with?
The making of malware.
Where, I mean, help
section 10,
10.1?
Section 10 speaks to the, my apologies, I'll just read it. It speaks to the manufacturing, selling, importing, distributing, disclosing, or otherwise making available a computer, any key, or any other data or device. And so within the definitions of that would capture malware.
So are we saying under the definition of what? Data? Because it's not very clear to me that we could be talking about malware. So that's why I just want to be understand. So we're saying under data.
Right, because computer keys and data are defined in the legislation.
Okay, thank you.
And Chairman, committee members, that would be the ministry's comments on at least 3 of the recommendations, and I will now pause here and hand over to the Legal Reform Department to treat with the
All right, me again. What about the other recommendations from MOCA? And the reason I'm asking this is MOCA is an important partner for this piece of legislation. And as such, I'm just curious, what happened to the other recommendations that we have made? I noticed you spoke to 1 and you did indicate you'd only speak to 1. What of the others? Is it that we're accepting them?
No, member, as I indicated, the Attorney General's Chambers, Legal Reform Department, and the OPC would have been asked to comment on various, or to opine on various comments from stakeholders. And so the LRD, who I'm deferring to now, we'll treat with all the other comments that would have been made by both the Director of Public Prosecution as well as MOCA, PSOJ, etc.
Okay, thank you so much.
Good afternoon, Chairman. Good afternoon, members. I'm not sure if the members are seeing or hearing us.
Here we're seeing a new look, you.
Yes. Are you hearing me clearly?
Clearly.
Okay. So when we were looking at the recommendations from the various stakeholders, our research has been quite extensive on Section 9. So what we're proposing today is to break it down and perhaps pause at the end of each segment, just to give members an opportunity to ventilate on it, and if anything, we can respond to questions if the committee doesn't mind. So how we're proposing to start is to highlight certain issues from a case law perspective based on the existing, some of the terms in Section 9. So the members would have recalled, based on what CTD Moriat said, that the Office of the Director of Public Prosecutions, as well as the PSOJ, had indicated that there are challenges with the term obscene. And the challenges largely relate in terms of defining what obscene means, or the practical prosecution of it. From our research, there are several laws in Jamaica that deal with obscene publications. We have an Obscene Publication Suppression of Act, we have the Towns and Communities Act, we have the Post Office Act, and we also have Section 9 of the Cybercrimes Act. The thing that we would wish members to appreciate is that there is currently, based on the amendments that were done to the Constitution in Chapter 3, Section 1312B preserves pre-existing laws prior to the amendments to the Constitution that deal with obscene publications. And the Cybercrimes Act, having been enacted, well, reenacted in 2015, would not enjoy that level of protection that deals with obscene publications. So with that in mind, I just want the members to also appreciate that when the concept of obscenity first arose in law, it was really based on moral standards. And the court largely was responsible for being the judge of what was moral in society. So the test that the courts developed to determine whether something was obscene is to look at the obscene material and to determine if the effect of the material was to deprave or to corrupt the minds of persons who were open to immoral influences and into whose hands that type of publication might fall. So what this empowered the court to do, and what often happened, is that even if you published a material and let's say the publication was to alert the public to a potential issue, or it was for satirical purposes, the court could use an excerpt from the entire document and determine that the entire publication was obscene. So the first case that we saw that considered that concept of obscenity, it was actually published by a religious group, and they were making criticisms of another religious group. So a part of that publication contained some lewd references, and the court essentially said that notwithstanding what your motives were in terms of providing criticism on issues, the material contains obscenity. So it operated in a sense to, although you were protecting morals, you were also preventing people from publishing documents that could highlight potential immoral issues. What we have seen since then is that there are a number of countries who have moved away from that test. Jamaica still uses that test, although at the time of research, we've only seen it used once, maybe in a 1970 decision of the Court of Appeal. And what the courts have been saying is that that test contravenes individuals' rights to freedom of expression. But in Jamaica, we now have the additional right of the freedom to seek and distribute information. So what courts have been saying is that countries such as Kenya and India, when they examine legislation equivalent to the Cybercrimes Act, they found that provisions that criminalize the publication of obscene data or menacing data or even grossly offensive data, a term which MOCA has commended to the committee, they've struck down those provisions on the grounds of being constitutionally vague and potentially criminalizing persons. So persons, as PSOJ has indicated, would not have appreciated that their conduct could potentially be viewed as either obscene, menacing, or grossly offensive. It was also causing problems for the prosecutors, problems for police officers and other persons involved in the criminal justice process. So from our perspective, we do think that as it stands, Section 9 and particular could potentially be challenged on the grounds of a similar contravention of rights, like freedom of expression and freedom to seek and distribute information. What some countries have done is to actually define what an obscenity is. So for Canada, for example, they have limited what they consider to be an obscene publication to refer to the undue exploitation of sex or sex that is coupled with like violence, horror, crime, etc. So in light of that discussion, one of the options we recommended, if the committee is minded to consider, is perhaps to impose a statutory test to determine what an obscenity is, or it could also attempt to define some of the terms that are being proposed, such as menacing, grossly offensive, and obscene. So MOCA has provided examples of what they think something grossly offensive is, and that could be included in the definition of grossly offensive. I'll pause here in case the committee has any questions based on this analysis from the Legal Reform Department.
I will say to you, Mr. Basco, that I support the idea of, creating the definitions for certain terms and to have it explicitly stated in the legislation.
I would only add that I think, given how critical this one is, that we add some public education around this particular issue. It's probably the most controversial aspect of the cybercrimes legislation, which affects a lot of people. So the definition is a good first start, and I think we should ensure we publicize it.
Chairman, I have a concern here, and I was trying to actually comment on the last section that Miss Mori, commented on. The perception or the usual observation of what might be obscene is granted. Yes, there is a standard to that. But I wonder if there is also a role of including the word knowingly somewhere. I'm not a legal mind, of course, but there is a circumstance where, let's say, someone is fearful of spiders, and it is known that this person is fearful of spiders, and it is not an obscene image. It is not I'm not sure if this, because this is, I'm also commenting regarding the previous point that was being discussed with Ms. Moore, and I could not chime in at that time, my connection or something, I don't know. But there are situations where a person might have a unique predisposition or predilection to being offended by something, and it might not be considered by the standard that would be applicable. And so I don't know if there is a role for us inserting knowingly, the offender knowingly offends the individual in that way, if that can be considered. Thank you.
Chairman, we have a position regarding Member Longmore's recommendation, but I don't know if CTD Mori also would want to interject first.
Chairman, members, no, because I think the LRD will address cumulatively what the recommendations are in respect of this section.
Okay, thank you. So what we have just given to the committee is one option to treat with the concerns raised, and it was concerns regarding the vagueness of the terms that are currently used in Section 9, as well as MOCA's recommendation for the term grossly offensive to be used. We do have other options for the committee to consider, one which we think could address Member Longmore's point, and we will treat with that if the committee is minded when we get to that recommendation. In relation to what the members, Member Gale and Member Robinson had said, we also wanted to indicate that currently what happens, especially in relation to obscene publications, is that the Obscene Publication Suppression of Act, while it criminalizes publication of obscene materials, the fines in that legislation are very low. So it's I think when last we checked it was perhaps about $40.
Yeah.
While the Cybercrimes provides a higher fine. This potentially creates a problem in the sense that persons may, instead of opting to use a computer to commit the obscene offense, opt instead under one of the other laws with a lower fine. So even in the Town and Communities Act, I believe the fine for a similar publication of obscene materials is about maybe $1,500. So
the penalty isn't high enough to bring it under Section 4.
And the penalty may not be high enough to bring it under the Cybercrimes Act. So we say that because from our perspective, we do think that the law generally in relation to obscene publications requires some level of reform, but we did indicate the savings provision in the Constitution, and we stand to be guided by the chambers, but it's our understanding that any amendment to those laws which have been saved will remove the protection to those laws. And so we just want the committee to bear this in mind as to the potential disparity between what is obscene and how it's punished under the Cybercrimes Act versus the various other laws that also punish obscenity.
Mr. Basco, I hear what you're saying with regard to that, but I am not as concerned because this is the other acts that you refer to are older. And so we can understand them not having more applicable penalties. But I don't think we should use that as a reason not to do what we know needs to be done in this one, because we don't want to go backwards. We want to move forwards. And as such, we do what needs to be done here. And if it happens and it can fall under the cybercrimes, this is the penalty. When those other acts are updated, then we ensure that they come into the modern era as well.
Thank you, member. We were just providing it by way of context for the committee to note in terms of how obscenity generally operates under various laws and potential issues. The other issue that was flagged by the Financial Services Commission has to do with the requirement of sending data to another person.
I'm sorry, we weren't going to finish with MOCA, or are you coming back to it?
We had dealt with MOCA's aspect in terms of the grossly offensive. We haven't yet touched on the recommendation regarding hate speech.
And about permutations disjunctively versus conjunctively.
That is another recommendation we will treat with when we give the general recommendation or final recommendation in terms of a potential repeal and replacement of Section 9.
Okay.
So the FSC had indicated there's a potential issue with the term send data to another person. And from our research, we've seen one 2018 case from the UK in which a person had written something which was offensive in relation to a healthcare worker, I believe, but it was done on a blog, and charges were laid against that individual, but the charges were subsequently dropped because the court found that the concept of sending data to another person does not contemplate the posting on your own personal page, even though it could be posted in such a way where the person who you intend to have an effect on is easily able to see it. So what we have done, we've done some research generally in terms of the trend in which the world is moving with these types of offenses, these types of sending data offenses. And what we've noted is that a broader term is used, which is defined to include a lot of things. In the recommendation that we make to repeal and replace Section 9, we suggest that the term publish be used, not within the context of publishing to another person, but that term would be defined to capture all the various ways in which a person can send data. So it would capture things such as if you wanted to go live on social media, or if you wanted to post on a page on social media, but in circumstances where you readily appreciate that the intended victim would see that type of data. So I pause here regarding our position on the term send data to another person for the committee's consideration.
So, Mr. Basco, just to be clear, you're recommending that the definition be broadened to include where you would publish something on your own social media, which would have the same effect as if you sent it via WhatsApp or email.
Right, we're suggesting that instead of predicating the offense on sending it to another person, the offense is one of publication. And we would see what publication means.
Yeah, and you would define that.
I don't know if any other member has a question regarding that proposal.
That seems agreeable to me as well. Do you have any of the definitions to present today? Sorry, Mr. Basco, can you hear me?
Yes, sorry, I was looking for it. On page 48 of the matrix, that is, we suggest a definition of publish to include sending, transferring, posting, disseminating, or otherwise providing access to data. I don't know if CTV Murray is able to find it, but it should be on page 48 of the technical report.
Okay, all right, thank you. So the idea is that this captures those, say for example, the trolls on Twitter and the full gamut of social media who just put stuff out there, even as you mentioned on their own social media page, etc. The idea is that this captures all of them as well.
Right, yes, that's the intention.
Perfect, perfect. All right. And is there something about tracing IP addresses and those things so we know exactly who the sender is?
Well, we think that perhaps would be something that would be incorporated in the law enforcement's investigative powers under the Act. We weren't yet convinced at this time that there was need for a legislative amendment to treat with that investigative power.
Okay, because why I'm asking is because somehow the trolls are still empowered to just do and say as they feel. And there have been some concern, by members of the public that, I mean, yes, you go to the police station and you say that this is what's happening and this was the information that's out there, but then it's I don't know, there seems to be a roadblock to say, well, how do we find the person? How do we trace the person? I'm not sure. But I would have thought that in terms of following up with IP addresses, etc., you can know which computer was used, which device was used. You could even know the location, etc.
That's a fair point. We actually done some research into the practical investigation of these matters, and we realized that countries do still encounter problems because of the nature of technology and how increasingly easier it gets for a person to block their location and perhaps even their identity. So even though the police still have this investigative power under the Cybercrimes Act, the question of whether or not the technology will evolve in such a way that it is practically increasingly difficult to locate those persons.
All right, thank you.
Okay, I'm not sure if any other member has a question or comment. Okay. So we move on now to consider hate speech. And this was a recommendation that was made by MOCA. We, at the time when MOCA made the recommendation and when we were reviewing the submissions, we did not see any parameters of the offense provided by MOCA. It was a recommendation just to incorporate the term hate speech. We have noted that Jamaica is a party to several treaties that deal with an obligation to eliminate hate speech. And if the members look to page 49 of the technical report, we highlight there 2 conventions that deal with hate speech. That's the International Convention on the Elimination of All Forms of Racial Discrimination, which was signed in 1966 and ratified by Jamaica in 1971, and the International Convention on Civil and Political Rights, which was signed by Jamaica in 1966 and ratified in 1975. The challenge with MOCA's proposition and having regard to the issues in other jurisdictions is that in order to implement an international obligation, first of all, it would require the input of various stakeholders at the ministry level. It would have to flow from a policy about the types of matters that would be criminalized by way of hate speech. And what we were seeing is that different territories are not settled on the concept of what is hate speech. So in the UK, for example, I think, or was it Scotland, there was a case in 2016. There's legislation that criminalized hate speech in relation to identifiable groups. And what happened was that a pastor had preached about the religious views of the Islamic community and made certain pronouncements against them and was prosecuted for hate speech. And the court dismissed that criminal prosecution on the basis that that member was exercising his freedom of religious beliefs. And we've also seen a carve out in other jurisdictions where fair comment, even if it's a discussion expressing antipathy towards another group, does in fact is a permissible excuse from the whole concept of hate speech. In the European Court of Human Rights jurisprudence, what we were seeing is that hate speech is not protected at all. And in Canada, there are very specific offenses such as promoting genocide against an identifiable group, and an identifiable group includes persons of a particular gender, national or ethnic grouping. So from our position, if a decision is taken and if the committee is minded to include hate speech as an offense, it would be difficult to start from the perspective of the Cybercrimes Act without an acknowledgement generally of what are some of the things that could be considered in hate speech. And we think that this should benefit from the widest possible consultation, particularly because it engages several rights under the Constitution, namely freedom of expression, right to distribute information, freedom of religion, and given the test that we now have to meet, we are suggesting and that the ministry that has responsibility for information would need to take the lead on that matter, hate speech and publications of that nature. But from our perspective, the issue of hate speech isn't universally settled. And so Jamaica will have to now decide what types of matter are having regard to our international obligations and our constitution should be included in this concept of hate speech. But up at this point, we're not in a position to say that it can be incorporated specifically for the Cybercrimes Act.
Well, question, again, Mr. Chairman, through you. But so how do we reconcile? I hear you on the hate speech bit, but then in terms of matters that are defamatory in nature, how do we reconcile that? Because I hear you on the constitutional points and freedom of expression and fair comment and all those things, but we do have laws. I mean, the defamation laws limit that. So yes, you have a constitutional right to freedom of speech and expression and thought and fair commentary and all of those things, but those things must be considered within the within the realm of for laws that protect someone from being defamed. So in the same breath, they trying to defame someone on social media, which is I suppose if you're attacking them and it's obscene and all those things. I mean, can't we capture that somehow together? I mean, can I pull all of that together somehow?
Well, you're right in terms of the permissibility of passing laws that could abrogate or infringe rights. The challenge is going to be meeting the test on the oath. So you would have to have the legitimate aim, the measures must be rationally connected, and they must infringe on the rights in the least punitive matter. A question of proportionality. What we are saying is that at the time of research, we have not seen any indication that would satisfy the requirements of the Oakes test. So it would be, for example, yes, there are issues for defamation. The jurisprudence that we saw around defamation is, yes, there's a right to freedom of expression, but as far as it could potentially affect someone else, there are permissible derogations. What the court has said that they will construe all laws that potentially impose a criminal sanction for defamation very strictly because it's a question of proportionality. So although some types of defamatory offenses can be criminalized, in other instances, we're seeing a movement towards the court potentially saying they would strike down those provisions. So all we're saying, we're not disagreeing in principle about hate speech, but we do think it needs to come at a higher level. The SG had indicated earlier the process in relation to international conventions and the role of cabinet, etc. In order to ensure that we have a law that properly could satisfy the Oakes test, what we are suggesting is that level of detail and the guidance given from our courts as to the approach we should take should be adopted, but without more and without any understanding of from their stakeholders of what types of matters we think should go into hate speech and what we think hate speech should be, we potentially run the risk of including provisions that could be struck down if they were challenged.
I want to agree with you on this. And when it came up earlier, that's why I asked for some clarification about what the definition of hate is, because it can be on the grounds of someone's sexuality. It can be on the grounds of religious beliefs, ethnicity, a number of factors. I mean, I give you one example. You know, if I said that I believe the Israelis are committing genocide against the Palestinians, that can be considered an anti-Semitic comment. It can be considered within the realm to maybe Israelis as something that could be considered an offense of hate and qualify as a hate crime. Now, I would defend my own right to express my opinion and view. So I don't think it's something we should include because I believe it would infringe on your own constitutional right to freedom of expression. We have laws of defamation and libel and slander, which can be used where people cross that particular line. But I certainly would not want to have criminalized opinions which may be other people view in a particular light and have a different view of than yourself.
But well, all right, fine. I hear you, Member Robinson. But what about where there is inciting someone in that respect? So you put out a publication and you say all Palestinians are dogs and they're fleas and they're rats and they should be killed, and people should go out and attack them and take away their land and kill them. I mean, that is a completely different thing from expressing an opinion. So, I mean,
well, that's different. You may be inciting people to commit a criminal offense, which is to kill
right,
people.
I think you clearly are.
That's different from expressing a view.
No, exactly. But it comes under hate speech. So that expression is hate speech. So I think, in other words, I agree that there's no set. Perhaps there's no set international definition of what hate speech is. But I think in a modern democracy, And I think looking at a modern law, and I mean, and yes, we spoke about, I mean, Member Campbell Rodriguez mentioned as well that, you know, we have very old legislation. So this is a modern piece of legislation. I would like to think that Jamaica would join the league of modern democracies in moving forward a modern piece of legislation that then captures the full gamut of cybercrimes and hate speech or hate has been translated to a side of cybercrime as well. So, I mean, in other words, to completely ignore it is one thing, but were we to include it and then let the courts decide on a particular instance, whether it is, as you mentioned, your right to opinion in one instance, in your example, or my example, it's a clear hate speech with an intent to incite hate or crimes against a particular group of persons or an individual, and let the court decide if this falls within the definition of what might come to be accepted as. So therefore, we don't miss out on an opportunity to have a very progressive piece of legislation.
The question I would ask, and the SGs here, are there other laws currently that would protect someone in a case that Minister Terry Long raised? You know, if somebody incites violence, is there a law that can prosecute somebody for doing so? You know, if you're saying I'm encouraging people to go there, go kill Palestinians, then an action flows from that. That could be inciting, could be accessory to the particular offense. But I am just cautious about us including it, because I think in the absence of definitions, it becomes what were considered normal, not normal, but acceptable opinions 20, 30 years ago are not now, and may not be 20, 30 years from now. But, you know, a lot depends on, you know, your perspective and views on life, and whether you want to. I'm cautious about criminalizing things like that.
Mr. Chairman, I just want to also add my thoughts on this. We have to, at some point, accept some of the recommendations that are given by the people who work in the field every day. Hate crime is something that, hate speech is something that the world is grappling with. We're living in 2022 when this is something that the world all over is grappling with. We cannot be saying we're looking at a cybercrime, and a lot of people who are not normally brave are using methods to deliver their hate speech. Because a lot of things people say online, they would never say to your face. I think we need to protect people by including something. And also, MOCA is the one who made this recommendation. They deal with this on a daily basis. We have to listen to some of, I notice that we are just saying no to absolutely all the recommendations from the agencies and the entities that have submitted to us. I am yet to hear even 3 things that it is recommended to us that we accept. These are the people who work in the field every day. One of the things Mocha said is that the legislation is as such where it is difficult for them to prosecute using it. We have to listen to them. And as such, I'm agreeing with Minister Terry Long that we do need to ensure that we include hate speech in this bill. We can't just say no to absolutely everything that is recommended. And Mr. Chairman, through you, I'm going to ask that even after we finish with Section 9, I personally would appreciate if the team could tell us, just give us the list of the things they have accepted so I can prepare for next meeting. Because everything so far is, we are not accepting, we're not accepting, we're not accepting. How can we not accept things that are being brought from MOCA, from DPP, from the University of the West Indies, from the minute? How can we? At the end of the day, you're going to hear that it is us, the legislators, who have said no to all of these things. We have to change the way we approach this, reviewing this bill, or it makes no sense for us to spend 2 hours every week to be the recommendation to us. We don't accept the people who work in the field and need our support to make things happen in this country. No, Mr. Chairman, I would appreciate, Again, if the team can tell us which of the sections, which recommendations are you accepting? Because right now everything is no. And it is really frustrating for me to come here and all the recommendations are, no, we're not listening to anybody. Because at the end of the day, myself as a legislator will be accused of not listening. So please, before we pass section 9, before we move into 10, please tell us what you're willing to accept so we can work backwards.
Mr. Chairman, can I just say, I've heard what Member Campbell Rodriguez has said, and I certainly don't adopt a view of not listening to recommendations or advice, but I believe we have a responsibility to evaluate them, assess them, and determine whether we believe them to be in the best interest of the legislation. I certainly support some of what the DP, no, but I support, for example, the DPP has spoken, there was a recommendation about definition, there was a recommendation about the term obscene. I support those things. So I'm not taking a view.
It's not about you. I'm not talking about the opposition here. I'm talking about the persons from the ministry who everything they have said. Last week also you weren't here, so you missed it. Everything. If we felt as though I felt as though I was going to battle. I'm not talking about the opposition in this instance. For a change, I'm not talking about you guys, Julian. I'm talking about the fact that the ministry is coming back to us. The technocrats in the ministry are coming back to us. And constantly, every single thing, we're not accepting. We're not accepting. How can we not seriously accept what Mocha is saying? They're the ones using this legislation more than everybody else. How can we be saying no to everything the DPP is saying and actually have a justification that nobody else accepts, except the person's giving it to us? It has to be a change of mindset. It is as though the aim is to keep the legislation the exact way it is. And so this is just a process of just talking. There are changes that need to be made. So let them tell us, first of all, which ones are you willing to accept? And then we move from there so I can do my homework and know that all the other recommendations you're going to say no to, so I can come prepared. Because I expect to be given advice. That's the purpose of the ministry. We hear what the public has said, all these agencies. Let us then really be willing to accept some changes. Julian, it's not the opposition.
Mr. Chairman,
I know, but in fairness to the technocrats, I don't know. Again, Natalie, I would say, even if the technocrats don't agree with something, we can still, based on our own assessment, determine what our view on it is.
True,
even
but
if
it's
they don't
tiring
agree
with
with
everything, Julian. It's really tiring. They have not yet accepted one thing.
No, but hear me, no.
It's true. Let us examine it. Let them tell us what
I mean, when this
accept.
legislation was, which I mean, they've given their perspective, and their perspective is theirs. We can disagree with their perspective. If they don't agree with it, I mean, we don't have to accept that.
But it becomes, so just give me a list then and say to me, I accept one of 100 things that the professionals working in the field have said. And then I can come and prepare. But every week I come as though I'm a joker and expecting to be given advice other than we do not accept. I am sorry, but that is unacceptable. And us as legislators, especially those on the government side, will be accused wrongly when it is not. So I'm sorry, I'm going to continue being combated in this committee unless we have a change where at least, come on, not even 40% of the recommendations from MOCA or from DPP or from all of these entities can be accepted. It's just no. We don't have to be this way. Come on.
Chairman.
Go ahead, Member Gill.
Chairman, I can understand and appreciate the concern raised. Having been a member of various joint select committees, where this is a consultative process that invites recommendations from the public and stakeholders and people in the various field of operation. Certainly what would help me in terms of the matrix thus far is an update of the matrix to identify those areas that may have been accepted for us to just highlight them as part of the update. But I can appreciate the fact that there may be the need, given the fact that this is a important piece of legislation that, you know, continues to change and will continue to change because of the environment to which we are living in. And so what is being suggested is that we ought to look at some of the recommendations to see how relevant they are and how we can infuse them in this new change that we're dealing with, so that it brings some relevance to it. We're not going to be able to review this for another 5 years, possibly. And so if the players and actors of the process have made some recommendations, then let us see if we find merit to some of those. I agree with Member Robinson, you know, that we can also, as committee members, reject what has been put forward by the technical team if we are strongly of the view that it should be infused. But what we're asking the technical team also is that if there is a strong feeling and we find merit that some of the recommendations ought to be accepted, then maybe they can find ways as to how to relevantly incorporate it. The other point I would want to make is that we'd also want to hear from the technical team, given the fact that this is a dynamic piece of legislation. What is it that they are going to recommend or inform us to be incorporated as possible changes going forward? So that for me would be a very critical reference point, which I would certainly like to embark on. And I want to lay that on the table, Chair.
So, Member, I take your point, and I have listened to Member Campbell Rodriguez, and just to say that it's important that we know that if we do feel strongly on a position, then obviously, as the policymakers and the legislators, we can change it. I think what would be better, obviously, would be for, as you said, for the technocrats to look at what recommendations are there and to see how our sentiments can be accommodated based on the recommendations that have been made and our support for them. But I think what is critical is to do an assessment, as Member Rodriguez said, in relation to what has been put forward by the presenters and what has been accepted. That will give us a clear indication on the where we are so far. It is of import that the DPP and MOCA are critical agencies of law, and therefore, obviously, what they recommend would be based on their experience, would be based on their day-to-day experience. So that's not just an ordinary recommendation. That's coming from a very significant authority of the country. So I do take that point. But the fact of the matter is that at the end of the day, we are charged with making the recommendations for the changes. But I will ask that we do an assessment of exactly what has been put forward and what has been accepted and what the ministry is indicating should remain, and that will give us a clear indication as to how far we are apart. But I take the both points that have been made, both by the 3 points by Member Robinson, Gale, and Rodriguez Campbell. And I will also say that as you said, this is a review from the previous act. And therefore, based on how fast technology is moving, etc., it cannot be that everything or most things remain the same. Not in a world such as this of technology. So CTD, we would want an assessment done in relation to the recommendation made by Member Campbell.
Chairman, the request for the list of what has been accepted vis-a-vis what has not will be prepared.
Thank you.
Chair?
Ms. Grant, go ahead.
Yes, thank you, because I'm very concerned by what I just heard. And I would just like to reiterate that certainly for my part as a participant, as part of the technical team on this committee, I consider my role to give advice, legal advice, which is based on sound footing. And I don't want to have the feeling that I'm being asked to compromise that legal advice for the sake of trying to be amenable to comments that were received from the public.
Sorry, Chair, Marlene Aldred, I also have to echo Ms. Grant's views. From the perspective of the Attorney General's chambers, we give legal advice. And that advice is based on our research and our findings. It is then left to the committee to decide what it wants to accept and what it wants to reject.
Noted, SG, and accepted. And I think that's the point I was trying to make earlier, that you have made very, very bluntly for me. Continue, CTV.
Well, Chair, sorry, I just want to reiterate. I've heard. No, I just want to reiterate on the specific issue of hate crime and the incorporation that I support the view put forward by Mr. Basco not to incorporate it. I know my colleagues have different views, but at this time I support the view not to. I have strong reservations about its inclusion and the criminalization of it, particularly given that there are very different views on issues of religion, sexuality, and ethnicity. And those tend to be the areas that hate crimes are committed in. And yeah, as I said, I'm very wary of including that in criminal legislation at this point in time.
Mr. Chairman, again, for the record, I'm going to repeat my point through you that I think it be included, and at the relevant time, if it is that the matter goes before court, etc., then the court can determine if the particular act, publication, speech, etc., falls within the realm of a hate crime. And as I indicated from my example, two examples were given. One in which Member Robinson expressed what could fairly be considered an opinion. The other, which is clearly an attempt to incite crime and violence against a particular group of persons. The example cited by us, well, just for argument's sake, the Palestinians. But I do believe that, and even from what Mr. Basker has said, that when a matter comes before the court, it then falls on the court to determine whether or not this can properly be called a hate crime. But we cannot, as a modern democracy, I mean, in our 60th year of independence, looking at a modern piece of legislation, leave out something that is critical in terms of cyber crimes and attacks that are made daily on individuals and groups of persons. I think it's important. Let the court decide if something falls within the meaning or international standards.
But I had asked this question, but I didn't get an answer from the technical team. The example given by member Terry Long of somebody who makes a posting about encouraging or inciting people to commit murder. My question was, is there other legislation that that individual could be charged under in Jamaica right now?
Member Robinson, Legal Reform Department here. Yes, there is. When the anti-gang legislation was enacted, an amendment was done to the Offences Against the Person Act to include a provision criminalizing the use of audiovisual or audiovisual communication to promote criminal activity. Section 18A criminalizes the production, recording, selling, importing, performing in public, circulating or playing a recording of an audiovisual or audiovisual communication that promotes the killing of or other serious act of violence against any other person or category or group of persons. So I'll just stop there because that is specific to the issue that we were discussing.
All right, thank you, thank you.
Chair?
Go ahead.
Right. From a legal reform perspective, we just want to join with the Attorney General's chambers and the OPC in terms of their responses a while ago. We just want to record for the record that what we are saying as a law reform department and our approach to reform in Jamaica is that we are not opposed in principle to provisions being made regarding hate speech. We do recognize our international obligations. What we are saying is that we have serious concerns based on the guidance provided by the court that to attempt through the Cybercrimes Act to introduce hate speech, that it is likely that this provision could be challenged on constitutional ground. The courts are going to examine, just by way of example, why is it that the government decided to proceed solely by way of the Cybercrimes Act when the issue of hate speech is so important. They will ask questions as what facilitated the definition of hate? Why did the government choose to limit its understanding to this particular thing? If it is that the committee, notwithstanding these constitutional reservations, feels the need for it to be inserted specifically in the Cybercrimes Act, we'd also ask that the stakeholders who made the recommendations, if they could reach out and provide guidance as to what they were thinking as persons who are likely to use this legislation of hate speech. It would certainly lead the direction in terms of any discussion on whether or not this type of offense is permissible and could satisfy the 13(2) derogation provisions of the Constitution.
I just have a question, and I'm asking within the concept of being new to the parliament, and so maybe don't understand, and as, again, not an attorney. But why do we have to go back to who made the recommendation if here in the committee we're saying we would like it to be included, and I think Minister Terry Long has indicated some really good reasons, and if other members are asked, I'm sure they could speak as to their opinions on it as well. Why do we have to go back to who made the recommendation versus what is being said in the meeting? Just so I understand the process.
Right. So as we understand it, the committee is considering or is minded to consider the insertion of hate speech. One of the things we have to think about is the persons who are going to be using this legislation. So that's your investigating authorities such as MOCA and prosecuting authorities. MOCA's recommendation was for the implementation of hate speech. What we indicated earlier is that there is no universal acceptance of a concept of hate speech. It differs from jurisdiction to jurisdiction. Because of the vital role that MOCA is expected to play as a stakeholder, and the DPP as well, we would need guidance from them as to the thinking of what hate speech, what types of matters they're contemplating for hate speech. But that's our thinking.
Go ahead.
So Chairman, we would just be turning to the final recommendation that we had made, that we would be making. And this is broadly in relation to the issues that the stakeholders had commented to the committee. And it's because they viewed the Section 9 in its existing form as very restrictive, in the sense that it's restricted to data that's obscene, threatening, or menacing in nature. And so, having regard to the concerns of the committee, including the Office of the DPP, regarding the vagueness of the terms obscene and the recommendation to remove it, we are suggesting that Section 9 be repealed and replaced to provide a new offense that is essentially data neutral, in the sense that the type of data is not qualified as obscene, menacing, or threatening, and it is done with an intention to harass or cause fear or harm, or the apprehension of fear or harm. If the members have the technical report with them, we set out what we think are some possible things that this new Section 9 could include. And what we are proposing, and this is subject to discussion and the views of the technical team as well, is that a person who, without reasonable excuse, publishes, and we've indicated what the definition, sorry, I see CPC grants hand is up.
Sorry, Mr. Basco, I would just wanted you to just, I was waiting until you were finished at least the first point there, but I just wanted to ask, I noticed you have reference to a person who without reasonable excuse, and then you also have a reference to the intention to harass or cause harm. So I was wondering why both, because is it that a person could have a reasonable excuse for intending to harass or cause harm? I'm wondering if it's the reasonable excuse part is necessary in the context.
Oh, no, I think it was one of an alternative that we were suggesting. In the event that it was possible that we were not contemplating something, our initial recommendation was to limit it to an intention, but we recognized that perhaps there was a possibility that maybe the members might think of something, and so we only flagged it there as illustrative to invite a discussion on whether there was a thinking that there's other types of activities which could take it outside of the Section 9. But it's not something we're tied to, and we would actually prefer sticking to the intention. So it was really for discussion purposes.
No, Mr. Basco, I saw it as an alternative. When I looked at it, what came to my mind was that the two represented an alternative option.
Okay, we just wanted to clarify then that our starting point really is we prefer it to be coached or limited to the intention, but the reasonable excuse that we have here was really to invite a discussion in terms of whether or not members thought there was anything that should come out that would take it outside the scope of the proposed new 9.
Could you just repeat for me what you are proposing to replace with? I'm on my phone, not my computer, so I can't read the screen. What
Okay.
your proposed replacement of that clause in Section 9 is?
So what we're proposing is that the new section would provide that a person who publishes data intending that it should harass or cause harm, or the apprehension of harm to that person or the person's property commits an offense. We think that the mental element for the offense should be an intention to harass or cause harm or the apprehension of harm. And we think harm, we know there's been this discussion earlier about psychological harm, psychiatric harm, and mental injury. And so we just asked the committee to note that we're still doing research about a possible definition for mental injuries, which could have implications for the term psychological harm here. But our reason for saying that harm should be defined as including both physical and psychological harm is just for the committee to note that our courts currently consider harm to include both a physical and psychological component, and there's case law to this effect. In determining whether the defendant intended to harass or cause harm or the apprehension of harm, the court should have regard to the following non-exhaustive factors: the context in which the data was published, the characteristics of the recipient of the data, such as the age, the sex, the relationship to the sender of the data, the content of the data, the frequency with which the data was published, the extent of the publication of the data, and whether the defendant took any steps to retract the data after it was published or took any other action to mitigate the harassment or harm. And we repeat there the definition for publish, and we have recommended that we retain the provision that speaks to the Labor Relations and Industrial Disputes Act. We have also recommended that the committee considers a potential recommendation to be made to the Ministry of Justice with a view to amending the Criminal Justice Law Reform Act. Currently under that act, it allows for certain types of assault-based offenses to go to mediation if the judge considers it an appropriate offense to go to mediation and the parties agree that to go to mediation. We think that a soft approach might be required to this new Section 9, and so before even fully going to trial, that this is an avenue that could be considered as a tool to address the ills of this type of publication online to cause harm or offense.
So, Pascal, let me ask you a question, and I'm going to give you 2 examples and tell me where they would fall. In Jamaica, the taking of pictures of crime scenes has become a common norm, and people either send them via WhatsApp. So somebody has been shot and killed, and somebody takes a picture and then it goes viral. That's one example of whether sending an image of somebody who has died, which would certainly cause psychological harm to relatives or friends of the deceased, where that would fall. And then secondly, there are gangs who, part of their criminality, when people are killed, I've seen one which is probably the most macabre one I've seen, where, after killing somebody, they started to dismember the person. And pictures, somebody filmed it, right? And that again went viral. Give me an example, for those 2 examples with your new definition, tell me how those would be treated. So the first is somebody just taking an image because it may have happened outside their house. The second is where, a criminal element to cause harm to friends, relatives, drive fear into the other members of that gang, film something and put it out there.
Okay, I'll take the second one first, just to say that we think that that second example would be something that could be prosecuted under the new Section 18A of the Offences Against the Persons Act. I mentioned about the use of audiovisual or audiovisual communication to promote criminal activity. We do think that type of specific example would fall under Section 18A. In relation to your first point regarding the recording and subsequently sending, could I ask if it is that the person who recorded, did they intend, or are you saying that they intended in that situation to send the recording to those specific persons that perhaps a family?
No, they didn't. So you're passing an accident scene and there may be bodies on the ground. The person takes it, sends it to their friends, but it goes viral and it reaches family members before they're even notified of the person's death. And this is a daily issue in Jamaica. But the original sender didn't intend to create harm, but there's harm that is created when certain recipients receive that message. What would happen to that person, or even the persons who forward that kind of image, which generally happens now?
Well, it's 2 things. The first is that there would not have been an intention in that circumstance. So the mental element that is required would not be satisfied. But I wanted to give you a bigger example of how something similar operates in civil proceedings. So in negligence, for example, that type of example that we gave, the court has not recognized the injury that arises as a result of that. They found it to be too remote. So the test, as we understand it, is that there has to be some level of proximity in terms of the relationship between the parties. There should be proximity on the part of the person who suffered the psychological harm to the event in terms of whether it was at the scene or the immediate aftermath. And the courts have not recognized data, that type of data sent to a third party or in a newspaper and causing that harm as foreseeable. So from our perspective, that recording would not have been captured under the newly proposed section 9.
Mr. Basco, Chair, through you. Again, I am wondering about the use of the word knowingly, because again, it is bringing to focus if someone knows that a particular individual has a predilection to a particular circumstance and intently circulates or intently exposes that person to that. There is, I think, an act that is offensive and that is punishable, and especially if it is repeatedly done. So again, I am waiting patiently to hear, it was indicated earlier that my suggestions before would be accounted for. So I'm waiting patiently again to hear if this is being considered. Thank you.
Thank you, Member. You raised the point about the knowledge. In that particular circumstance, that knowledge then rises to the level of an intention. Having known that a person has a particular predilection, and you send the data with the knowledge of that person's predilection, that satisfies the requirement of the intention to harass or to cause the apprehension of harm or to in fact cause the harm. So it's three things. The intention will either be to harass, it will either be to cause the apprehension of harm, whether it's physical or psychological, or thirdly, it would be to actually cause harm. So in the example you have given, the knowledge would be akin to an intention.
Okay, so then it would be satisfied. So there's no need for the use of the word knowingly.
Right, correct. I should have indicated I was addressing your point.
Good. Thank you.
I'm not sure if the members have any other question before we treat with the DPP's proposal for revenge porn / intimate sharing of an intimate image.
Go ahead, Mr. Basco.
Thank you, Chair. Having regard to what the DPP has indicated and the rationale that they have provided for the offense, from our perspective as a law reform department, we do agree that it deserves a special treatment under this law, based on the specific recommendation from the DPP. So we're not adding anything new in terms of what should be done, because I think the DPP, the office of the DPP, dealt with it pretty comprehensively. And again, I think the only other thing that we would say to the committee is that based on some jurisdictions that we have seen, this type of offense is done in a very technologically neutral way. So it not only contemplates the sharing of the intimate image or the video using a computer, but it also criminalizes other forms of publication. And that is the only thing that we would bring to the committee's attention.
Mr. Basco, you want to continue?
Those were really all of our recommendations, Chair. Just one other point, my colleague Incitement was just reminding me that what the DPP has contemplated could also be included in this new section 9 that we have proposed. It's sufficiently wide, so there is no need to take into account the whole issue of consent, because once it is published with an intention to harass or to cause harm, this type of provision would address it. And it would also address other types of offenses such as cyberbullying and cyber stalking and cyber harassment, which we can revisit later, because we understand that the ministry was going to treat with general recommendations, and we can have this discussion within the framework of those new offenses, and to see if the committee is satisfied that this new 9 could deal with those general recommendations. That's it from our end, Chair.
All right, thank you, Mr. Basco and your team. We are up on 4 o'clock now, so we've spent 2 hours. CTD, what's left on the matrix?
Chairman, based on the conversation that was, or the statements that were made earlier, I'm not sure if there's any merit in proceeding any further. As I indicated, we'll do the list of the recommendations that have been, that we consider that can be considered for acceptance, and we'll share those with the committee. But I'd just like to say, Chairman, that the technical team at the ministry would have reviewed every single stakeholder comment. We would have reviewed those comments against existing legislation in other jurisdiction, against a convention that is in place, though we're not a party. And based on our review, would have made our recommendations to the committee. As indicated by the LRD and the AGC, if the committee is not minded to accept our comments and or recommendations, it is certainly within the committee's right.
So members, I think based on the fact that we are going to have a lapse between now and the next meeting, which is being proposed for April 21st because of the pressing matters of the joint select for the Firearms Act, that we will have time to have the caucus that we spoke about at the last meeting. I think it's more than timely now, especially in light of some of the comments that were made today, so that we'll be able to look through not only what the CTD is going to provide, the ministry is going to provide us through the CTD in terms of where we are in terms of the matrix to date with the recommendations from the other from the persons who presented, and to see what the matrix looks like in terms of the recommendations from them and what has been proposed by the ministry. It will always give us an opportunity to go through the rest of the matrix so that we can discuss it prior to coming back on the platform and have some kind of consensus in terms of the issues. So I think we'll set that, and that will be our caucus just for the members of the Joint Select. And I think that will give us a chance to air some of the concerns that were raised today and be in a position to come back for the meeting of April 21st. So I hope that proposal is widely accepted by the committee members, and we will be in touch with you in relation to set a date, a mutually convenient date between now and the 21st. The 21st is at 10 o'clock or 2 o'clock?
10 o'clock.
10 o'clock on the 21st of April. Okay.
Chair, the proposal as suggested was accepted by me. Some changes would have been proposed for number 9. I would like to see how that plays out, what it would look like as part of the reference.
Sure. Noted, member. Yeah, that's noted. So we are looking now at the confirmation of the minutes for July 14th, which were inadvertently not done, and of course, our last meeting of February 3rd, 2022. Can we get someone to?
Mr. Chairman, just to correct, our last meeting was not February 4th. We had one, I think, the 17th.
So we're still outstanding one set of minutes. So this is from 2 meetings prior.
Correct. So we'll catch up on that at the next meeting for sure. So this would be just July 14th and February 3rd. July 14, 2021 and February 3rd, 2022. Can I get a confirmation?
So moved, Mr. Chairman.
Seconded.
Second, Chair.
Senator Gale, thank you very much. Any matters arising from the minutes? All right, so we have the confirmation and a seconder. Under AOB, I already spoke to that in terms of the caucus and the next meeting. So we're just a little over 4 o'clock, 4:08 to be exact. So good timing. And hopefully the caucus will bring us clearer and with the consensus going forward in terms of the review of the matrix so far, and of course, the outstanding matrix. So until such time as you hear from us, keep safe, and thank you very much to the ministry team, and of course, all the supporting agencies for the presentation, and the Ministry of Education. Thank you and good afternoon.
Come ring the alarm. The dust has finally settled. The day of reckoning has arrived. Only 2 sounds have been left standing. Rough Cut and Kush International. All scores will be settled this Saturday night, February 26, 10 p.m. in the final showdown of Echoes of Sound Systems. It's a dancehall thing. Who will be the Reggae Month 2022 champion sound? Will it be Rough Cut? Rough Cut! To them, will it be Kush International? Kush International! Catch all the action on PBCJ, JCDC Facebook page and across social media this Saturday, February 26, 10 p.m. Echoes of Sound Systems. Another exciting Reggae Month event.
Together, we can create a safer Jamaica for our children. We need to get the guns and save our country.
Without